Hello everyone. Uh, I hope everyone is fine. So I think you're doing great nowadays. So the pandemic is going on. I hope you all are safe. You're wearing mask and helping each other in this dreadful situation. So today we'll start with a new topic, which is application of foreign judgment in the private international law. Now, this is a very much important topic which is to be covered today. This is because, since we know that private international law is not binding all the parties until and unless the party himself chooses to apply the law by himself. So, until and unless they chooses the law to bind on himself, it will not act as a binding factor. So we have different types of conflicts. We have the conflicts of domicile, we have the conflicts of residential status, we have the conflicts of renvoy. There are several and many other conflicts regarding the private international law. And apart from this all things, another most important thing which is to be considered during passing of any judgment or order is the application of foreign judgment. Now we have to see. Let's take an example person who is a citizen of India and who has been residing in America. A divorce petition has been filed in America by her wife in America. And if the case comes and if the decision of the case comes against the husband who is a citizen of India, so will that be applicable to India as well since he is a citizen of India? Nevertheless, he has been residing in America, but he is a true citizen of India. So, what if the husband chooses to live in India, and what if what if he does another marriage? So, will that be applicable in India? To for knowing these things, so today we will study about the application on foreign judgment, which is also an essential element to determine the judgments under the private international law. So, what we see is that the application of foreign law in practice is often difficult and time consuming. For a variety of reasons, the increasing codification of private international law raises question as to how legislature propose to cope with the consensual consequential burdens of the administration of justice. This article provides comparative observation with a view to shedding some light on the practical difficulties that China, with its relevant recent private international may wish to consider. Now, flexible approach to the ex officio application of foreign law and renvoy is encouraged, as well as the use of information sharing bodies, specialist private international law institutions, and specialist judges for the determination of the content of foreign law. Moreover, the improvements and greater efforts in relation to the supply of foreign legal information on the international level can easily be made. In any event, the fallback solution is the case of difficulty. The application of Lex 40 itself is problematic from the perspective of incentivizing the application of foreign law. In the process of application of foreign law, the overall problem of private international law reaches a special and one may say specific culmination. This process brings together a number of problems of fundamental character whose importance stands out quite clearly when we realize that it is precisely the application of foreign law which constitutes, under certain factual and legal premises, The specific feature that made the private international law a special entity within the system of law, which in this culmination differs from the other branches. So, what does it state? What is all about recognition and enforcement of foreign judgment? So, a court, whether established by Indian law or a foreign law, is a part of a government that maintains balance between the state on one hand and citizens on the other hand, or between the citizens and citizens. So, it functions as a backbone of governments under the rule of law. Throughout the whole world, courts are identical. Administration of law and justice is a vital job of the state. Therefore, a judgment, whenever given by the highest court, carries respect and is honored for what it decides and how it decides. So, recognition will generally be denied if the judgment is substantially incompatible with the basic legal principles in the recognizing country. So, if any judgment is passed which is not legal in the principles of that country, so in such case, such judgment will not be acceptable in that country. So now we move on to section 2 of the CPC 1908 of India. Now what does it say? First we go to the meaning of the foreign court. A foreign court means a court situated outside India, not established or continued by the authority of the central government. Next we come to the foreign judgment. It means the judgment of a foreign court. So with the advent of globalization and with the Indian poised as the major international global player in the world economy, it is apposite to consider the law concerning enforcement of foreign judgment in India. In law, the enforcement of foreign judgment is the recognition and enforcement rendered in another jurisdiction. Foreign judgment may be recognized based on bilateral or multilateral treaties or understanding, or unilaterally without the expense of international agreement. So it's not mandatory what the legal procedure is, but you can go with the foreign treaties itself, and it is conscience to say that it will be recognized in judgments. So India's social and moral and religious condition along with the public policy will be decisive for determining the matrimonial law, including jurisdictional aspect applicable in India, and harmonization of law cannot be achieved at the cost of the ignorance and sacrifice. The court can refuse to apply a rule of foreign law or recognize a foreign judgment or a foreign arbitral award if it is found that the same is contrary to the public policy of the country in which it is sought to be invoked or enforced. Under Section 13 of the Code of the Civil Procedure 1908, if foreign judgment is not conclusive as to any matter thereby directly adjudicated upon between the parties, if it has not been pronounced by a court of competent jurisdiction, or it has not been given on the merits of the case, or it is found on the incorrect view of the international law, or a refusal of recognize of the law of India in case in which such law is applicable. Fourth, we have the proceedings are opposed to natural justice, or it is obtained by fraud. And next, it sustains a claim found on breach of any law in force in India. It is thus clear that in order to make foreign judgment conclusive in India, it must be shown that it complies with all the above mentioned 6 conditions. If there is no compliance of any one of these conditions, the foreign judgment will not be conclusive and consequently not legal, effective and binding. A foreign decree of a foreign court is normally recognized by a court in another jurisdiction as a matter of committee and public policy. But no country is bound to recognize and give effect to a decree of a foreign court if it is repugnant to its own laws and public policy. So today we'll stop over here. In the next class we continue again. We'll see how it goes. Till then, thank you very much. Have a good day.